in Black Diamond Property Owners versus Black Diamond Properties.
Good morning, Your Honors, and may it please the Court. My name is Denise Lynn, and I'm here on behalf of the Black Diamond Property Owners Association, Incorporated. I request at this time...
Well, I guess that begs the question, right?
Yes, Your Honor.
Who you're here on behalf of?
Yes, may I please, before I answer that question, reserve 5 minutes of my time for rebuttal?
Thank you.
Judge Torpey, I am here representing the Black Diamond Property Owners Association, Incorporated. And unfortunately, there has been some confusion in the record as to who actually represents Black Diamond Property Owners Association, but unfortunately, that question can't be answered until a court, either this court or the trial court, or whether this court affirms the trial court's decision, decides finally whether or not the developer had the right, when it tendered a letter on October 13th of 2003, removing a majority of the directors of the Homeowners Association's Board of Directors. Once a court decides whether or not that was a valid removal, that will answer the question as to who represents the association. If I'm successful and my clients are successful, then this court would determine that the developer did not have the power to remove a majority of the elected board. If we're unsuccessful, then this court will affirm the trial court's decision that the developer did have that power, or some of the other reasons that the trial court determined.
Is there in the articles a break point when the ownership transfers from the developer to the members of the association?
Your Honor, that wouldn't be found in the Articles of Incorporation. The Declaration of Restrictions and the bylaws do have some language within them that do address turnover of the association as well as control of the association's board.
Is it based on a numerical number or lots or residences?
Your Honor, the bylaws provide do not address that, other than the fact that in the earlier years, the developer, until a certain requisite percentage of lots are sold, the developer has a 3-to-1 voting preference. So the bylaws address it by way of the developer gets to vote 3 votes for every 1 vote of a non-developer-owned lot. So that's what the bylaws.
Let me ask you this way: do you agree that that the association is governed by Section 3.6 of the Declaration in terms of turnover? That that's the controlling provision in the Declaration?
I believe that is one of the controlling provisions. However, we can't lose sight of the fact that Florida Statutes 617.0808 governs all not-for-profit corporations, including this not-for-profit corporation, in how the board of directors, any director, can be removed from a board of directors. And that statute overrides any counter provisions in any deed restrictions or bylaws. In fact, the provision provides that, and I have it cited on page 20.
So are you arguing that a developer can't retain control at all of an association because once he appoints directors, they can only be removed in accordance with that statute?
No, that's not what I'm saying, because the distinction that needs to be made is whether a director has been appointed by the developer.
But that's a distinction that you're making. That's not a distinction in the statute, is it?
Yes, the statute makes the distinction of elected directors. We certainly agree that if a developer has control of an association's board and he or she has the right to continue to appoint directors, as in the very beginning, the very first board of directors of an association, the developer would appoint those members. So long as he continues to appoint those members of the board, then we would say he has the right to continue to control. However, as happened in this case, the developer gave up that right. He actually allowed the membership of the corporation to have a free and open election and elect their directors.
Section 3.6 there says that there are 2 ways that he can give up control of the board. One is if 100% of the lots are sold, and it's undisputed that that did not happen, correct?
Correct.
And then the second is that he, at his sole discretion, elects to turn over control and evidences that by recording a letter of turnover in the public record. Is that correct?
Yes, that is.
And that never happened either, correct?
We disagree there, Your Honor.
Well, it would be pretty easy to do a public record search to see if that turnover document was in the public record. Are you saying that it's in there, or you don't know? Or?
No, there is no record of turnover that is recorded in the public records. However,
why can't a developer do what this developer says he was intending to do, which is say, I still control the association but I'm going to allow an election just to see how things go while I control the association. If I don't like the results, because I control it, I'm going to replace the director. If I like the way it's going and like the control, I'll go ahead and turn it over early. I mean, why isn't that an option?
Because unfortunately, the developer did not have other documents which supported that. First of all, Florida Statute 617-0808. It is the only provision that relates to an elected board. Now, if the developer had seen fit in the bylaws, which is common in a lot of plan developments, the developer will make provisions in the bylaws to either set up the preferential voting scheme that we discussed and is apparent here, or it will say that the provisions of removal don't apply to appointed directors. Those are options that a developer has. I do want to go back to the specific provisions of the document that you referenced. There's a two-step process there in the language that you quoted. The language says he has the right to maintain control, and inherent within that part of the sentence is he has control. He has to maintain that control or retain that control. And then if he decides at some earlier date other than 100% sale, he can choose, which we say, our position is, that he chose, when he allowed elections, a free and open election in December of 2001 at the annual membership meeting, that's when he chose to give up that control.
And I take it from your argument that it's just the fact that he allowed elections that you're drawing that conclusion from. In other words, there's no document or no statement that goes along with that that says, I'm now turning over control so you can have elections. It's just that there were elections, and so you're assuming that that was, or you're arguing that that necessarily meant he turned over control.
That, in effect, was the turnover of control. The mere recordation of the notice of turnover in the public record simply serves to put the world on notice that turnover has occurred. That doesn't effect turnover. It simply recites that turnover has occurred. The actual action of allowing the members to serve on the board and allowing the members to elect the members of the association to elect their representatives to the board, that act is what we feel is where the developer gave up control at that point in time. And he not only did it once, it happened twice. It happened in December of 2001 and again in December of 2002. Things were moving along smoothly, although there were some bumps in the road, as is common with homeowners associations and developers. But there was no outstanding events that occurred during those first 2 years. It wasn't until this letter that was tendered on October 13th of 2003, at that point in time, the developer said, you know what, I'm removing you. Well, it's our position that under 617-0808, he did not have the power at that time to exercise those provisions of the deed restrictions.
Before you go to another point, let me ask you this. How is it possible that you can amend a complaint in a case that's already been dismissed? As I understand the procedural history of the case, once the letter was delivered, the new board directed that a new attorney be hired, the case was dismissed, and then you came in after the case was dismissed and filed an amended complaint. Is that correct? Is that accurate?
Yes, Your Honor. I'm sorry, I don't remember the exact terms of the court's order. I wasn't counsel at that time, but the order dismissing the complaint allowed for an amendment. I think it was either I hate to say, but I believe it was like a 20-day or a 30-day time period that Judge Thomas allowed the pleadings to be, or the initial complaint to be amended, and that's where we filed.
I misunderstood. I thought it was a voluntary dismissal by the plaintiff.
There is some discussion within the record about a voluntary dismissal. That was filed after Mr. Merriam purportedly was hired by the board.
And before you filed the amended complaint?
I hate to say for sure. I'm not exactly sure when that was filed, but I'm sure Mr. Merriam can address that. I apologize. I'm not quite sure on that. Your Honors, we are here today asking for...
Let me just ask, assume that that's true. Assume that there was a voluntary dismissal before you filed the amended complaint. How does the court continue to have jurisdiction? Why are we here?
Because it is all wrapped up in the whole issue of who is the actual association. Which board...
But I mean, even assuming that you didn't think that the party that filed the voluntary dismissal actually had the authority to represent the party, wouldn't you have to have that set aside, go in and file a motion to set aside the dismissal on grounds that the person that filed the document wasn't authorized to represent the association, rather than just filing an amended complaint and trying to go forward in a case that had been voluntarily dismissed?
I believe that the court, and I'm very remiss in not knowing at what point in time that dismissal was filed, so it's difficult to answer the question. But I believe that the dismissal allowed for amendment, and the amendment was filed within
I'm talking
the
about the
time.
notice of voluntary dismissal.
And I'm sorry, I really can't recall when that dismissal was filed, whether it was filed before or after the amended complaint. So I really, it's difficult to answer that question particularly. However, it all stems.
Okay, according to my notes, the notice of voluntary dismissal was filed 2 months before you filed the complaint, second amended complaint on behalf of the association. So assuming that my notes are correct from the record, how can you go forward with a lawsuit when the lawsuit has been purportedly dismissed by the association of plaintiffs?
It would be our position that that was that pleading was not a proper pleading.
But you never filed a motion to set aside the dismissal on those grounds?
No, no. Now, the court did entertain a motion to dismiss that was filed on our second amended complaint, and the grounds that were raised in that motion to dismiss were the grounds that I did not represent the homeowners association and that I didn't have authority to represent them. And the judge denied that motion to dismiss and allowed us to go forward. So inherent within the court's ruling on that motion to dismiss, and the specific grounds of the motion was that I didn't have authority. They also brought up some conflict issues, but the judge summarily denied that motion to dismiss, and we moved forward. So at that time, I would think that Judge Thomas was certainly aware of the arguments and proceeded accordingly. Your Honors, we're here today. Actually, there were 2 motions for summary judgment filed. We're here actually arguing one order which dealt with both of those motions for summary judgment. The association filed a motion for summary judgment based upon the issues that we've discussed, Judge Lawson, the 61708 provisions, the provisions of the bylaws, and the developer's control. We would state it's clear the application of 6170808 to the undisputed facts show that the trial court erred in denying that motion for summary judgment. Secondly, we're also here contesting or challenging the trial court's granting of the motion for summary judgment that was filed by the developer. The trial court simply did not adhere to the fundamental principles of fairness in granting that summary judgment based upon matters that were not raised with particularity in their motion, and also that were not...
Didn't you waive that argument by not raising that below? I mean, in looking at the record, the only thing you point to is a question, which affidavit are you referring to? You never said, we object to this hearing, these matters weren't raised with particularity. You just argued the motion. I mean, the law is very clear that in order to preserve an issue for appeal, you've got to raise it to the trial judge and get a ruling on that legal basis. You can't just turn to opposing counsel and say, which affidavit are you talking about, and expect the trial judge to know that that is an objection to the procedure that's being used, or a due process objection.
I have 2 points in response to that question, Your Honor. These issues were specifically addressed to the trial court when the trial court had an opportunity to remedy them. There was a properly and timely filed motion for rehearing that was filed following the hearing, raising exactly these issues that counsel's argument went outside of the particularity of their motion, and raising defenses to, or not really defenses, but bringing up some factual arguments in opposition. So the trial court did have a fair and ample opportunity to remedy the situation by granting a rehearing where we could consider those arguments. So that would be the first point. The second point is the case law that was cited basically states that when you have a procedural irregularity, those things need to be objected to. But it's important for the court to understand the process we were in. We weren't in front of a jury. We were not. We were in front of a sophisticated trial judge. We were having argument of counsel. As officers of the court, counsel, we are to know what things are proper for us to argue and what things are not. It is very difficult when you're in the heat of the argument, so to speak, to continue to interrupt counsel. And I would state that the question...
To me, that seems pretty simple and basic. If you're in an argument on a motion for summary judgment and you're hearing arguments you've never heard and aren't prepared for, I mean, it seems like that would be the time, and I think that's what the law requires, when you would say, I'm going to object, this is not raised in the motion, if he wants to raise that, he needs to reset it for 20 days, follow Rule 1.510C. I mean, those kind of procedural objections are supposed to be timely, and it doesn't seem to be a difficult burden to meet if you're sitting in a hearing and you're facing something that you're surprised about because you've never seen it or heard it before. I mean, shouldn't we expect you to raise that timely?
I see that I have 5 minutes left, and I would like to say this.
Answer the question.
Yes. The second point that I was going to address is the matters that we are objecting to are not procedural matters. Their affidavits were timely filed. They were properly filed. Their motion was timely filed and properly filed under 1.510. It's not the procedural issues, it's the character. It's the way they were used. So simply using a affidavit that you file in opposition to another party's motion for summary judgment in support of yours is flatly incorrect and can't be used in that manner. So procedurally, we have no objections to how they filed their documents. It was how they were used in counsel's argument.
I mean, isn't that a procedural objection? This affidavit wasn't filed with the motion and therefore wasn't timely filed and can't be relied upon at this hearing. I mean, that's a procedural objection.
The affidavit was timely filed. It was filed 5 days before.
It wasn't timely filed as an affidavit in support of a motion for summary judgment, and that's your objection now, yes, that it was not timely filed.
And those were the objections that we raised at rehearing.
Okay.
You have 4 minutes remaining, ma'am.
Thank you.
May it please the Court, my name is Chris Griffin of the law firm of Foley and Lardner, and it is my privilege today, Your Honors, to represent the Black Diamond Properties Incorporated. As the Court observed right out of the box, so to speak, when counsel announced her appearance, it does somewhat beg the question as to who does, in fact, represent the Black Diamond Property Owners Association. Mr. Lauren Merriam is at counsel table with me, and with the Court's permission, I would like to be advised when I've used 10 minutes of the appellee's time so that I can make sure that he has time to address issues. Thank you. I would like to begin and perhaps end, depending on the time that elapses, with addressing the questions that the Court has posed to counsel, and more importantly, perhaps the answers that have been provided to counsel, especially, Your Honor, the most recent questions that you asked regarding the waiver of the argument that has become both apparently today and in the papers before this Court, the principal argument asserted by the appellant, which is that the trial court decided this matter on issues that were not properly before it because they'll argue.
I want you to talk about the merits first. So what do you say about her argument about 617-0808?
Yes, sir. 617-0808 begins with language, Your Honor, which qualifies its application to situations in which the issues addressed by that statute are not otherwise addressed by the organic documents of the condominium association itself. In this case, Your Honor, those issues are addressed by those organic documents by, indeed, the section that was referred to in the questioning to counsel, which is Article 3.6, which, and it's interesting, Your Honor, that when this section was cited in the initial brief by appellant.
Does 3.6 deal with the procedures or the substantive right to control the association?
I think it does both, Your Honor.
Deal with procedures to remove a director?
It deals with the right to retain control of the association until the developer has, and then it recites what happens. But then later,
the developer can put directors in there to control the association, and the developer can tell the directors what to do, I guess. But if the developer wants to remove those directors, how does 3.6 help me with the procedure for the removal?
Your Honor, I think it's implicit in there is another provision which gives the developer the right to appoint, as he maintains control or as it maintains control, to appoint all members of the board of directors. Clearly, Your Honor, if one reads together the retention of the control under 3.6 with the concomitant right to appoint all members of the board of directors, the notion of control means all aspects of control. And it seems, Your Honor, that that right to appoint necessarily carries with it the concomitant right to, under the proper circumstances, remove a director if another director in the discretion of the...
I'm with you all there, but what's the procedure for removing the director?
Exactly as this developer did in this instance.
Send them a letter?
Yes, sir.
And where does it say that that's the, I mean, you know the difference between substance and procedure, right?
Yes, sir. My point is that...
Procedure is, is the way you go about, doing something. I mean...
And if I understand the court's question, the fact that this specific procedure is not specifically identified in the documents, in our view...
Well, there's no procedure in there for removing the director.
But implicit in control, the retention of control and the right to appoint necessarily carries with it the right to remove. The fact that...
Yeah, on that. You got me on that one. You don't need to tell me that again. I mean, the developer's got the right to remove, but, this darn statute right here says that it's got to be pursuant to this. If there's no procedure in the organic document, then this procedure controls.
Well, and
the director, right?
I read 617.0808 a little differently with respect, Your Honor.
It uses the word procedure. I mean, I didn't make that up.
But it seems, Your Honor, that, and I forgive me if I sound like I'm repeating myself, but I think the point I'm trying to make in the notion of the retention of control, which carries with it the ability to remove, and I know Your Honor's question, which is, okay, where does it say how I do that? The fact that, pardon me?
That is my
Yes, sir. Yes, sir. The fact that I don't want to use the word open-ended, but because it's not specified, but it's all-encompassing, it seems to us that the way that it was carried out in this instance is clearly within the permitted ways that one could reasonably carry out that retained right under 3.6.
But this so you're saying 617.0808, none of this should be deemed to be included within the Articles of Incorporation. None of that should be deemed to be included.
Because of the
authority provides the procedures for removing a director.
Because the documents of the association. That's correct, Your Honor.
That's your argument.
Yes, sir.
Okay.
On that same point, and then I'll come back to the procedural point that I began with. On that same point, as the court is aware, at the summary judgment hearing, the central argument on this point became whether there in fact had been turnover of control. And again, going to the language of the organic documents of the association, there simply can be no reasonable question that there was no turnover of control here. No authority was cited either below or in this court suggesting that simply allowing in some instance the election of directors implicitly surrenders control, especially when there is a specific procedure provided for in 3.6. And it was telling, it seemed to us, Your Honors, that in the appellant's initial brief, the language regarding the necessity of recording the notice of turnover was omitted in the quotation of 3.6, which of course is a critical aspect of that provision with respect to whether turnover or control had been turned over at the time that the October.
Let me ask you about the second way that the directors were supposedly removed, and that is by a vote of all members of the Homeowners Association. And I'm trying to figure out, and it's difficult from the briefs to figure out exactly where the dispute, if there is one, lies. I know that there's a question about notice, but I can't, is there a dispute that as to whether all homeowners got actual notice of I don't remember the date of the meeting, but the meeting at which that vote took place?
No, sir.
So the only dispute is whether there was a proper certificate recorded?
That is what, and this sort of carries over into the argument about of waiver and so forth. Mr. Dealey's affidavit, which was submitted in opposition, said simply it wasn't properly noticed. Never said how, never said why, never said what the deficiency was. The argument then occurred at the hearing, as Your Honor will recall, that there was this, again, suggested requirement that there be an affidavit signed by the party who sent out the notice. Mr. Olson, therefore, had filed an affidavit attesting to his actions from his capacity on behalf of the association of having properly sent out the notice. The fact that the affidavit did not exist in the records of the association, we suggested, was of no moment to the ultimate determination of whether proper notice had occurred, and no one has ever suggested, I sure didn't know about that meeting, and if I had been there, things would have turned out different, and I would have been able to say this, that, or the other. That suggestion has never even been made, much less substantiated. So there is no genuine issue of any material fact with respect to the notice that occurred about it.
Is there any issue of fact as to the vote taken at that meeting?
And I will say that I believe Mr. Merriam is going to address this as well in his time before Your Honors. There was an affidavit filed well before the summary judgment proceedings, and this goes back, Your Honor, to the waiver and the notice arguments, well before, I think over a year before, addressing another motion that raised some issues about the alleged invalidity of some of the votes by the corporation because there was no certificate on file with respect to the authority of the party who cast the votes. As I believe Mr. Merriam may explain in more detail.
You got 10 minutes.
Thank you, Your Honor. The applicable statute says that there is a presumption that an officer of that corporation has the right and authority to cast those votes, and therefore we believe that as a matter of law, that can be determined on this record, even if the issues that they sought to bring in after the fact.
That was raised on rehearing, correct?
That was raised on rehearing.
But at the summary judgment hearing itself, there was no argument, as I recall, that the vote was infirm in any way. In other words, it was sort of accepted that the vote was there as long as notice was sufficient to the members. There was a vote of all the members, and by a majority, the directors were removed.
That is exactly correct, Your Honor. There was no mention of that, no argument of it, no urging of it. It was raised, and I took a quick look, Your Honor, I have to say, in my notebook when counsel made the suggestion that the lack of notice that is now alleged to this court about what we argued at the initial summary judgment hearing was raised in the motion for rehearing, and I didn't see that, and I don't think it was argued. I think what was argued was what Your Honor just identified, and the other matters, which clearly under the applicable law, we cited the Wong decision, which I think is on all fours with this in terms of being able, as Your Honor observed, when you hear an argument come out of somebody's mouth and it's something that you never expected, and to digress, that has to fall on deaf ears. All of these issues were expected, understood before the court, before all the parties in counsel, and I don't think anybody can claim that they were surprised by anything that was argued. It wasn't objected to. The word objection was never uttered, and we believe any of those problems were waived by that failure to object in the trial court. We appreciate the opportunity to answer the court's questions. I will now defer to Mr. Merriam to complete the argument, and we respectfully request that the order below be affirmed.
You have 7.5 minutes total time remaining, sir.
May it please the court. I'm Lauren Merriam. I'm here as attorney for Black Diamond Property Owners Association. Listening to the questions that have been asked so far, I think the issue we need to address is the vote was overwhelming. That's why at the summary judgment hearing, it was just conceded. The vote was overwhelming. The amount of votes, the number of votes, that really wasn't argued because the vote was so overwhelming. As an introductory matter, The association has no objection to the individual removed directors bringing whatever dispute they might have to whatever forum exists against the developer. They should do that. They're encouraged to do that. The problem becomes when the association is involved in that without having given authority for that. And that's the issue. The trial court ruled that the removal was valid, therefore the case really didn't exist, and I had filed a dismissal, and that's the association's position. The case didn't exist once it was dismissed. Ms. Lynn was always given the opportunity to present her client's position, but ultimately the trial court ruled, no, this is an unauthorized case. If you'll recall that the statute requires any action seeking damages in excess of $100,000 has to have a specific affirmative vote of the members to authorize.
So and I gleaned this from the 04 cert appeal, not from this record, but the original complaint did allege damages in excess of $100,000, and I think the second amended complaint took out all reference to monetary damages, or the amount of the monetary damage.
You are correct. I argued that previously, and the second amended complaint, they removed it, but of course that was after I had filed a dismissal and after the court had entered a dismissal also.
Is the basic claim still the same? I mean, the basic causes of action are still the same. They've just taken out the dollar figures associated with it in the complaint?
The complaint runs dozens of pages, but I think the gist remains the same.
Okay. And there was never a vote of the association members. That was the argument in the 04 cert case anyway.
That's correct. That the members never authorized it, so the case was never authorized from the very beginning. And then the removal issue took place, and the new board instructed me to file a dismissal, and that was done. On the issue of, we didn't really get into the votes, council referenced the statute. The number is 617-0721, which says the officer is presumed to have authority. I assume the legislature's intent behind that was we have a lot of difficulty getting quorums and such in association meetings. Documents were in the past written, which made attainment of quorums very difficult. So the legislature has created the statute that now says, in the absence of a dispute, the person is presumed to have authority. Nobody has made any argument that I'm aware of ever that Mr. Olson didn't have authority to speak on behalf of the Black Diamond Properties. No one's made the argument that the proxies, he didn't have the authority to vote his proxies that he had received, Terry Legree's proxies. And when you look at all that, the overwhelming vote was, there's over 400 votes. The lots are 749, so to get to half, you'd have to be at 375. I took the arguments that were made by the purported plaintiff in one of their affidavits about they questioned this, but they came up with a minimum of 219 votes, of which 145 were in favor. And so if you add in, and they contested the corporate votes, they contested the proxy votes, but if you add those back in, you're well above 400 for every director removed. I didn't break it down. I picked the one who had the least removal votes, and still it was over 400. Unless you have questions, I'll defer back to counsel. Thank you.
Let's all be quite clear.
Let me just ask you this before we start, because it was a question in my mind having looked at the 04 cert case. Are you still alleging the same causes of action on behalf of the association that the original complaint said amounted to well in excess of $100,000 worth of claims?
No, Your Honor. The sole basis of our complaint is the board and the makeup of the board and how the board is going to be made up in the future. That's strictly what it is. But let's all be clear. There is nothing in the record about the voting, about how many votes were cast, who was eligible to cast, because those issues were not briefed in the motion and were not included in front of the trial court. Why? Because they weren't included. It's very important to look at the three items that were addressed in their motion for summary judgment. There's only
Wasn't
three,
that in
and they're
Mr.
very
Olson's
short.
affidavit?
In Mr. Olson's affidavit, no, Your Honor. The motion states simply 3 grounds. The motion raised that the attorney, Denise Lynn, was not authorized to represent the association. 2, that the terms of office of the directors had expired. And 3, that the membership had voted to withdraw from the litigation. There was no mention in their motion for summary judgment as to a vote of the members to remove the directors. There was nothing in their motion about a petition drive. That's why the trial court, in her findings, she made findings that they were removed by a vote of the membership, by a petition drive, or by the developer pursuant to its authority. The first 2 issues were never addressed in their motion. The only reason Mr. Dealey's affidavit addresses the notice provisions for the meeting that occurred was because he was refuting whether or not Mr. Miriam had been hired by the
you would
board
agree
or the
that
association.
am I correct that the vote of the membership argument was made as a basis for summary judgment, and you responded to those arguments, and your response was not, this isn't properly noticed or before the court, but you responded to that substantively by arguing that there wasn't proper notice? Is
The reason that I was arguing the notice provisions had nothing to do with the vote of the membership to remove the directors. The discussion was the vote of the membership to hire Mr. Miriam and the vote of the membership to dismiss the lawsuit, because the issue of the vote of the members to remove the directors wasn't raised. Mr. Dealey's affidavit, you will find nothing in there about a vote of the membership to remove the directors because it wasn't brief. And 5 days before the hearing, Mr. Olson's affidavit, I can't speak exactly to what it included, but it vaguely brought up the issue of the members' vote to remove the directors, but that was 5 days before the hearing. Certainly not enough time for Mr. Dealey or any other of the directors to file a responding affidavit because we were out of time. You have to have your affidavits filed 20 days in advance pursuant to 1.510. We didn't have that time. So when we got to the hearing, it was not anticipated that they would be arguing about the membership vote to remove the directors. I think it's important to respond to some of Judge Torpey's questions relating to the deed restrictions. The deed restrictions are an organic document, but there's also bylaws and articles. The bylaws provide a very specific procedure for removing directors. These bylaws were in effect at the time that the director tendered that letter on October 13, 2003, and I think it's important for the court to read exactly what the bylaws say, as they were on the date the letter was tendered. Removal. Any director may be removed from the board with or without cause by a majority vote of the members of the association. It doesn't mention the developer, it doesn't mention any letter removal, and the developer drafted these documents. When you look at an association, you have articles, you have bylaws, and you have deed restrictions. It's common to every practitioner that practices in this area of the law. You've got 3 documents. You draft them at the same time, you make them consistent. Unfortunately, for the developer, these documents were not consistent. The deed restriction said one thing, did not include a provision for removal. The bylaws did provide the provision for removal, but only by the membership, consistent with 617-0808. So there was no power for the developer at the time he tendered that letter to tender that letter and remove the directors at that time.
Well, he had the power to remove them, he just didn't use the right procedures. Is that your argument, or do you think he couldn't at all?
Judge, I respectfully, I do not believe that he had the power at that time because he
could tell him what
relinquished.
to do, but he couldn't remove them, is that it?
I don't think he had the power because he had previously relinquished that power by allowing a vote.
Nothing anymore. He's already waived his rights under 3.6.
Correct. That's our position. Imagine the members go to a meeting in December of 2001, assuming that they're going to elect directors to represent them on their board of directors. They vote. These directors take their position. They change their positions in reliance on that vote. They volunteer their time. They do their duties as good directors should.
Assuming that he had the power to control the association, and that we disagree with you on that point, then do you concede that he could make up his own procedure?
Yes.
Thank you, ma'am. That you've exhausted your time. You're going to have a chance.